All right, great. Thank you all for joining us for our presentation on the National Interest Waiver. My name is Dustin Saldarriaga, and I am a Senior Associate at Scott Legal PC here in New York City. Joining me today is my colleague Jie Huang, who is also a Senior Associate and has extensive experience helping clients navigate the National Interest Waiver process. We're very fortunate to have Jie here with us. A few housekeeping items before we get started. We do present several webinars a month, and these do span a range of immigration topics, from family immigration to business immigration, green cards to temporary visas. Our firm is a full-service immigration firm, so we do hope that you'll come to us with any immigration questions you have, whether or not they're related to business immigration. And we hope that you'll sign up for future webinars. We do record all of our webinars. This webinar is also being recorded. We post those to our YouTube channel, and we're very proud to make that available, that information available to you all for free on our YouTube channel. So do check out our YouTube channel. Not only are there full-length webinars like this one, there are also shorter videos on, again, a variety of topics. If you have a question during the presentation, please send it in either through the chat function on Zoom or through the Q&A function. I will be actively monitoring those. I plan to save all questions for the end, but we do plan to get through all of the questions, so don't hesitate to send those my way, and I'll monitor those. So after this presentation, you'll receive a link where you can sign up for future webinars, a link to our YouTube channel where you can watch those videos, as well as a guide on the National Interest Waiver and the PowerPoint presentation you see on your screen. So hopefully that will help reduce the amount of note taking you have to do. Without further ado, I will go ahead and pass it off to my colleague, Jay.
All right. Thank you so much, Dustin, and thanks everyone for joining us today. So let's start with the basics. What is a national interest waiver? And let's go through the basic requirements to qualify for a green card using the NIW. So as many of you may know, NIW is short for National Interest Waiver, and it is a subset of the EB-2 Employment-Based Immigrant Petition. And as you may know, immigrant petition means this is an application for a green card. So to obtain U.S. permanent resident status. And a green card gives someone the ability to live permanently in the United States and work for any employer or not at all. And having a green card also opens up the pathway to U.S. citizenship. Now, the EB-2 NIW is a popular choice among individuals who want to apply for a green card on their own, and that is called self-petitioning. And under self-petitioning, the foreign national can apply for the green card as an individual. By contrast, normally in the traditional labor certification process, you will need a U.S. company to sponsor you for a green card. However, if you qualify for the EB-2 NIW, you don't need the job offer. You don't need a U.S. based sponsor to drive forward that application. Now, the EB-1A, extraordinary ability green card is another pathway that allows self-petitioning by the foreign national. However, the EB-1A tends to really be reserved for individuals who have had many, many years working in their industries and have reached that top level of expertise to be among the few, the small percentage who have reached the very top of their field. By contrast, the EB-2 NIW could be a viable option for a wider variety of individuals who can show, even if they are relatively junior in their careers, that their work will make significant contributions to the industry or society more broadly, as opposed to just benefiting their immediate employers. So this could be a more accessible option for a wider variety of professionals. Now, then let's go through the eligibility criteria for an NIW. So the first thing to ask when you're preparing an NIW case is, do you meet the EB-2 threshold criteria? And the EB-2 threshold applies even if you're, just, being sponsored by an employer, for example. It's the same for to meet the criteria, regardless of whether you're applying for an NIW or through an employer-sponsored petition. You do need to meet the threshold criteria to be classified under the EB2 category. And so there are two ways to qualify for the EB2 category. The first way is by showing that you have an advanced degree. And an advanced degree is defined as a master's degree or higher, or um, in the alternative, if you have a bachelor's degree in your field, and if you have 5 or more years of progressive work experience in your field following your attainment of your bachelor's degree, then that can be combined to show that you have an equivalent of a master's degree in your field. So the equivalent of an advanced degree. So those are the two different ways you can qualify for under the advanced degree channel to qualify for the EB2. Now, one thing to note is that if your degree is from a foreign institution, so it is not a U.S. University where you got your degree, you definitely need to get what is called a U.S. education equivalency report from an accredited institution to prove that your foreign degree is equivalent to a U.S. bachelor's degree or a U.S. master's degree. And that is very important because in some countries, certain types of bachelor's degree, even if they are known as the bachelor's degree in their home countries, may not translate to a U.S. bachelor's or master's degree. And we have seen that come up in certain circumstances. So it is very important to, do that in advance and see, verify that your foreign degree will be equivalent to a U.S. degree of that level. Now, let's say you don't have a master's level degree. Let's say you don't have a bachelor's degree, or maybe you have a bachelor's degree, but you don't have 5 years of progressive work experience. And I did forget to mention that when we say progressive work experience, that is usually proven by a detailed letter from your previous or current employer showing that not only did you work for the full time 5 years, but also your duties must have changed over time to include more senior responsibilities, more complicated duties, such that the trajectory of your work is upwards. So in seniority. So this can be, described in a variety of ways. Job duties definitely important, but also if your title changed over time, such as you start from a junior associate to become a senior associate to partner, for example, or if your salary has increased in line with, the rising complexity and seniority of your duties, those things could be very important details to emphasize in, proving that you have that progressive work experience to qualify with your bachelor's and work experience. Now, so let's say you don't have a bachelor's, let's say you don't have a master's degree, or you don't have a 5 year experience. The other way to qualify for the EB2 threshold is by showing that you have exceptional ability in the sciences, arts, or business, basically in your field. And the government uses a two-part test to determine what is exceptional ability. One thing to note is that the criteria for exceptional ability is a lot lower than the criteria that is required for extraordinary ability, which is what you may know as the EB1A green card threshold. The extraordinary ability that they define there is very different from exceptional ability that they're looking for here. So to prove exceptional ability, all you need to do is cumulatively provide evidence that shows that as a whole, you possess a degree of expertise that is significantly above what is ordinarily encountered in the field. So it's definitely not like you need to show you're like the top 1% of your field, but definitely you do need to show that you are, a little bit more distinguished than what would be ordinarily expected from someone who is practicing your profession. So with regards to the required evidence that you need to show, at least 3 out of the 7 enumerated criteria here. So for example, if you have 10 years of full-time experience in your field and you can prove that by, detailed letters on company letterhead from your previous employers, that would be one way. And mind you, the 10 years of experience here, you don't need to show progressive work experience. 10 years is just 10 years here. So the two, work experience that we talk about are different. depending on which channel you're using to try to qualify. The other thing you can show is, high salary. That's pretty obvious. If you're a member of professional associations, and otherwise, if you have received recognition for your achievements in your field. And this can really be anything. There is a little bit of flexibility of what kind of evidence you can use here. So, for example, if you have, authored, a journal article, did some research and that has been cited a couple number of times, you can show that as one, area of recognition that you've had, or if you have won industry awards, or if you've earned certificates, of honor by, some government authority or a professional association covering your field, things like that, recognition in your field for something that you've done that is outstanding, or exceptional, or distinguished from what is ordinarily expected in your field. So definitely some creative advocacy can go in here. You can see that there is a little bit of wiggle room on what kind of evidence you can use to support exceptional ability. So that can be an option if the traditional advanced degree channel does not work for you. Now, once you have shown that you meet the EB2 threshold, the next step is to demonstrate that you qualify for a national interest waiver. And this part is also very important because, the other option is to get a US job offer and have the US company sponsor you. But when you're asking for a national interest waiver, you're asking for a privilege to be exempt from that ordinary requirement of a labor certification. So it is definitely very important to meet the three-prong criteria that we describe here to show that you do qualify for that exemption. So what are these three criteria? Now, these criteria is based on a case law called Matter of Danisar, which was promulgated in 2016, and it goes like this. The applicant must meet all three criteria, and the first criteria is that the applicant's proposed endeavor in the United States must have both substantial merit and national importance. And let's unpack that a little bit. So what does it mean? What does it mean to have merit? So substantial merit can be proven in a range of fields, including arts, sciences, business, even culture, right? And endeavors that tend to, further human knowledge in those areas, improve best practices, those things can be very favorable to show substantial merit. So kind of, giving a benefit to your field, giving a benefit to society in some way. Now, national importance is defined as kind of what is the impact of your work in the field, and does it go beyond helping just your immediate clients or just your immediate employer if you'll be working with an employer. So endeavors that tend to have national or global implications within a particular field by, advancing best practices, advancing technology, things like if you're in the semiconductor industry, right? If you're at the cutting edge of the industry on how these chips are designed such that, you increase the amount of data that can be given in a particular area or things like that, those kinds of technological advances. That's a good example of an endeavor, an R&D endeavor that can have global implications in the field by, kind of pushing the envelope of the industry as a whole. Things that the Matter of Danisar talks about include medical advances, improving treatments, coming up with new treatments for diseases that can, improve public health, things like that. Or another example that the Matter of Danisar talks about is improved manufacturing processes. So if there is a particular process that the industry typically uses, but if you, add on to that with an innovation on how things can be done differently that can improve efficiency for the field as a whole, those things would be very likely to be found to have national importance because it has broader implications for the field. The second criteria for the three-prong Matter of Danisar test is that the foreign national must be well positioned to advance the proposed endeavor. And what does that mean? The focus is on the individual, right? So the government will look at the individual's education, professional experience, and really a past record of related work that he or she has done that will position them well to drive forward the project that they're describing that has national importance and substantial merit. So really here, the focus is to provide a portfolio of what you have done in the past through your CV, through, data about your past projects, if you are someone who does research, publications or patents or things like that, showing what you have done in the past. If you're an entrepreneur, a record of your business achievements by objective evidence. Those things would be what the government will be looking at to see if the person is well positioned to drive forward the project. Now, the third and last requirement is that there must be a showing that on balance, it would be beneficial to the United States to waive the requirements of a job offer and thus of a labor certification. And the third requirement is more of like a balancing test. So what they will do is ask themselves, is the benefit of your proposed work in the United States greater than the ordinary benefit of protecting the US labor market by, the labor certification process requires a US employer to test the US market to see if there is an able and willing US worker to take your spot, right? So if they think that your work is kind of replaceable, right, then there really is no countervailing benefit to, exempting you from the labor certification requirement because the benefit of the labor certification requirement is that that job can be taken by a US person. And that's the policy that Congress intended when they put that that system in. But by contrast, what if you're an entrepreneur? And what if you'll be creating dozens of jobs in, an economically depressed area, for example? What if you'll be putting in so much investment and revitalization of a community? And what if that impact will be broader than the ordinary impact of saving one job spot for one US person? Those kinds of, balancing inquiries will happen in the third prong of the matter of Dinosaur test. All right. So then, how can the national interest waiver be used for entrepreneurs? So one of the things that we have been noticing, right, as we practice the NIW is that over the years, the NIW has become a more accessible and viable category for entrepreneurs to use as a potential pathway for a green card. And there are several reasons why that happens. So one thing is that with the new standards promulgated by Matter of Dennisar, the standards with which the government looks at NIW cases changed a little bit to make it a little bit more within reach for entrepreneurs. So, for example, one example of that is that now, under the new case law, the benefit to the U.S. interest can be local. So, before Matter of Dennisar, there was a previous case law called, New York State Department of Transportation, and they really looked at the geographical scope of the endeavor. So the endeavor had to be physically national in scope. That was the previous standard, but that really unduly limited, the option of entrepreneurs who really work closely with a particular community or a particular region to, qualify for the national interest waiver because their work may not physically reach all corners of the United States. But under the new standards of Matter of Dennisar, now it is possible for someone to be approved for the NIW even if physically the benefits of their work will be local. So, for example, if you are an entrepreneur and if you are setting up a business and providing a substantial investment in creating a high number of jobs and economic revitalization in a particular economically depressed area or region, and if you can get, sufficient evidence of how impactful that will be, you could use that as a basis to qualify, to find for the government to find that your work has national importance, even if the benefit is physically local. The other part of this puzzle is that entrepreneurs are usually self-employed and they usually cannot avail themselves of the traditional pathway towards a green card through getting a US job offer from another company, getting, that sponsorship that usually is required to qualify for a green card under employment. So what Matter of Dinosaur did is to explicitly mention that this is a practical limitation for certain entrepreneurs who are bringing an endeavor that is definitely of substantial merit and national importance, but the traditional ways of labor certification will just practically not work for them. So the Matter of Dinosaur explicitly noted that NIW could be a good option in those cases where there is that mismatch between the available available green card channels for entrepreneurs versus the substantial merit and national importance of the work that they're doing. So definitely after Matter of Dinosaur came out, we have been practically seeing more entrepreneur cases being filed and being successfully approved. And finally, when in the case law Matter of Dinosaur, the case law also notes that it is natural for, a business endeavor to have risks, as an intrinsic thing, right? So in the case law, there is also a mention that as long as you can show that there is a plausible basis for an endeavor to have this impact, to have national importance and substantial merit, it's fine if the planned endeavor ultimately does not succeed. So ultimate success of that particular business endeavor is not a requirement for approval of the NIW. And they do recognize that because of the intrinsic, nature of entrepreneurial endeavors, which have this risk. But they will look at, what is the substantial merit, what is the prospective impact of the work based on the business plan that you do provide. And as long as it is plausible, they will look at those plans. All right. So now then, let's shift gears a little bit and think a little bit more of the practical strategic considerations that may, come into play when you are currently on a non-immigrant visa and you're considering moving to a green card using the EB2 NIW. So let's talk first about timing. Now, it is important when we were talking about timing. I think it is important to note that the green card processing has two steps. So the first step is filing the underlying petition, in this case, the I-140, which is pretty much, the main part of the process where you have to prove that you're eligible for a green card. So that I call step one of the process. And once you once you are approved, right, for the I-140 and the government finds that you are eligible for a green card under that particular category, then what you can do is, well, first, your priority date must be current, right? And the priority date, if you're not familiar with priority date, just to provide a brief explanation, is that each year there is a limited number of green cards that can be issued for each category, and it's also kind of charged by your country of birth, so there are different categories, right? So there is a table that the government publishes every month, and you can see how much is the backlog, if there is a backlog. It's kind of like a waiting period before there is a visa available for you in that particular category, depending on your country of birth. So the priority dates, the reason why there is a backlog in many categories is because there are more people who are eligible and applying for green cards than there are visas available in any given year, and this creates the backlog. Now, if your priority dates are current, then you can move on to the second step, which is, the actual green card application. And you can do that either by filing an I-485 if you're already in the United States under a different non-immigrant visa status, or if you're not in the United States, or, for any other reason, you can also do that through consular processing, which means you will apply for an immigrant visa through your home country consulate based on the I-140 approval, and you will process that and go for an interview at your home country consulate. And once everything is approved, you will get an immigrant visa in your passport. And using that passport, you will come in and do the landing in the United States as a permanent resident. So those are the two steps, generally what is required to get a green card. Now, timing. So for the underlying I-140, which is, the NIW application, basically you showing the government that you qualify for a green card, for that one, premium processing is available currently. And if you pay a little bit of extra to sign up for premium processing, you will get an answer from the government, either it be a decision, either it be an RFE, a request for evidence, or it be, an NOID, notice of intent to deny, which is a little bit more rare. You will get an answer within 45 business days. It actually used to be 45 calendar days, but in some, At some point they changed it to 45 business days, so they definitely are taking their time. Now, let's compare that with regular processing. If you don't use premium processing for your underlying I-140, this means the I-140 may be pending processing at the government for many months and sometimes even up to a year. That will be my approximate guess. So it really depends on, what your priorities are. If you really want to get an answer quickly, then premium processing is definitely an option. Um, One thing to note though is that there is currently a worldwide backlog in the priority dates, right? So even if you get your I-140 approved, very quickly, you may need to be waiting anyway until your priority dates are current for the EB2 category. So it's kind of like a first come, first serve arrangement. So you will be given a priority date when you file the I-140. Um, and only when the threshold priority date that the government announces is um, later than uh, your assigned priority date, then you can apply for the second step of the filing an I-45 or filing for an immigrant visa. All that to say is that the current backlog is pretty long. And if you want more information on that, definitely schedule a consultation and we'll be happy to explain that to you further. But that goes to show that you could get an answer on the I-140 pretty quickly, but you may, be waiting until you can actually move to, the second step. But there could be benefits to having an approved I-140 strategically. There could be reasons for that as well. So definitely speak to your lawyer if you're, more curious about the details here. Now then, let's now shift gears a little bit and talk about the underlying visa status. So that is another important strategic consideration to have when you're considering filing an NIW is that if you are currently on a non-immigrant visa that does not allow for dual intent. Now, what does dual intent mean? Dual intent means that you're allowed to simultaneously have a non-immigrant, visa intent, like a work visa, like a TN visa, for example. You're coming in to temporarily work for an employer. Um, but if a visa category allows for dual intent, it means you're also allowed to have this long-term immigrant intent to apply for a green card in the future. Now, there are two visa categories that allow dual intent, and which is the H-1B and the L. So if you're on those two types of visas, then it is fine for you to be, applying for a green card, petitioning for a green card, things like that, even while you have the H-1B, even while you have the L. But for other types of visas, you will face differing degrees of risk when you apply for even the I-140, the underlying petition for a green card. And certain types of visas are more prone, to subject you to such challenge if you're trying to renew your underlying visa or try to apply for a new visa. And the TN visa is a good example because the TN visa is one of these categories where non-immigrant intent is quite strictly scrutinized. So let's say you have a TN visa and you need to renew it soon, but you really want to apply for the NIW, so you actually went ahead and filed the I-140. If you did that before you need to renew the TN visa, the next time you go to the border and talk to the CBP officer, they will they will see that in your record and they may ask you questions about it. Hey, you just filed an NIW I-140. Can you really, convince me that you don't intend to get a green card and immigrate to the United States? And that could, actually be quite challenging to have that conversation at the border. So in that kind of case, it may be better for you to go ahead and renew your TN visa first, and then once you're in the United States, after a certain period of time, then you can, take other action such as filing the I-140. And definitely that will to, definitely talk to your lawyer before making, strategic decisions like that. Now then, to go back to the application process to talk a little bit about that. I think I already mentioned this earlier, but the first step is to submit the Form I-140, which is the underlying application to prove that you are eligible for a green card under the EB2 NIW requirements. And if there is an immigrant visa available, and that means once your priority dates are current, such that you're at the front of the line after, the backlog has been satisfied, you may be able to, concurrently file an I-45. Now, for the EB2 category, for worldwide, the categories are not current right now, so concurrent filing is actually not available at this point for everyone in the world. But this may change, right? So, depending on what happens, right, with this backlog, which may improve in the future, hopefully, an I-45 can be filed if and when the priority dates are current. Um, and it is also possible for you to file the I-140 and use consular processing to apply for an immigrant visa abroad, um, and attending the interview there in your home country and getting the visa stamp before coming back to the United States. And you do have that option to choose if you're already in the United States, either to choose the I-45 or to, consular process abroad. And there can be strategic considerations with that. And this goes into the pros and cons of adjusting status in the United States versus consular processing, right? Because the disadvantage of using the adjustment of status process, which is filing the I-45, the disadvantage of that is that you can't travel outside of the United States once you file the I-45 while your application is pending until if and when you get approved for travel authorization, you can do that. But before you have that travel authorization, there may be a period of time where you have to stay in the United States waiting for, this pending decision, and it could take a while for you to get a decision on the I-485 or to get your travel authorization approved. So there could be that restriction that you face. So if you have a need to travel frequently, and if you do foresee the need to, go in and out of the United States, maybe doing consular processing could be a better option to preserve that ability to travel. Because if you do that, it doesn't matter if you leave the United States, you can still, have that, application going on in the background. The advantage of adjusting status in the United States, on the other hand, is that once you file your I-45, you don't need to maintain your non-immigrant status to continue living and working in the United States. And also, once you file the I-45, you're also eligible to file for what is called an EAD, the Employment Authorization Document, by filing an I-765. And once you have that EAD card, you can work for any employer you want while you wait for the I-45 to be processed. So that means you don't need to continue extending your underlying status in order to continue living and staying in the United States while you wait for the green card to be approved. By contrast, if you use consular processing and if you want to continue, working in the United States, the consular processing itself does not give any, independent basis for you to extend your stay in the United States, continue living in the United States. So you will need to continue to find a different way to extend your status. And in some circumstances, in some categories of visas, it may be difficult because you already filed the immigrant, visa petition. So it also shows immigrant intent. So there are a lot of strategic considerations that go in here. Definitely speak to a lawyer before taking any action. All right, so then let's talk a little bit about some updates that have come through with regards to how USCIS adjudicates STEM cases and entrepreneur cases. There were some favorable policy changes in 2022. And definitely, we are, very vigilant on monitoring any changes that may come in with the new administration coming in. And we will definitely be updating through various resources if there are any changes. So those updated guidelines are current as of now. And, what will happen to these guidelines, we will just have to wait and see with the new administration. So for the STEM specific guidelines, the important change that came down in 2022 is that the government published a list called the Critical and Emerging Technologies list. And if you are an applicant who is doing R&D in those types of technologies that are listed as important for U.S. competitiveness, you will have a leg up in being favorably adjudicated for the NIW if you can show that your work will have a role in advancing U.S. competencies in those critical technologies. And things like, AI, aero engine, agricultural technologies, engineering, materials, advanced manufacturing, things like that. I think we do have a blog up on our website that lists out those categories, and you can also look it up online. But if you're, an applicant who is engaged in research in those areas, you do have, you know, um, you could face, favorable scrutiny there. Um, Entrepreneurs. With regards to entrepreneurs, there were also some specific guidelines that were published in 2022. And really, the gist of that is that the government recognizes that some of the traditional metrics of proving influence may not really be applicable to the business field, right? So applicants in the business field may not be, engaging in scholarly research or publishing papers in journals or, getting citations, have a Google Scholar and things like that. So those traditional metrics may not readily be applicable to prove the substantial merit and national importance of an entrepreneurial endeavor. Then what kind of alternative evidence can entrepreneurs use to nevertheless show that they do have that influence? So some of these examples include, significant media attention, right, on either the applicant or the applicant's business. So if you are a business founder, and if you have, if your entity, the U.S. entity that you founded, has received substantial media attention, well, that can be one way to show your, the importance of your work, the prospective impact of your work, or, the innovation that you're providing to the field as a whole, even if your name is not mentioned in that media article. Similarly, awards and grants, either to your business or to yourself that you received from government entities could be helpful towards showing the substantial merit and national importance. Letters from third parties, such as government agencies, or even, industry experts, such as venture capital firms, established incubators or, accelerators, can be taken as authoritative evidence of the merit of entrepreneurial endeavor to the field because they are, considered as people who evaluate a high number of those types of ventures. Evidence of revenue generation and job creation, especially if the jobs are located in economically depressed areas in the United States, that can help prove the national importance of a entrepreneurial endeavor. And with regards to well-positioned, also a variety of evidences can now be used to support an entrepreneur's NIW case, such as ownership and critical role in the U.S. entity can be one type of evidence. Degree certifications, that's a classic example. Letters from, previous partners, previous employers describing the person's experience in the field with regards to entrepreneurship and other aspects. Evidence of investment interest from either government entities or just, private corporations. Even those types of agreements to invest could also be helpful in showing that your idea has traction. And as mentioned in the above category, history of revenue growth can also show that you are well positioned as an entrepreneur to continue driving forward that growth. And things like that. Media attention is always helpful for well positioned as well. So really, on balance, you can see that there are a good variety of different kinds of evidence that entrepreneurs can now use to support their case and build a persuasive collection of evidence for the government. All right. So then let's talk in a little bit more detail about what is included in an NIW submission. And an NIW submission typically is quite voluminous. It is an art of persuasion, so we do see many hundreds of pages of printouts. It is typical to accompany a NIW petition. So the first thing to include in an NIW submission is that you do need to include proof that you meet one of the threshold requirements for the EB2. And there, as I mentioned before, there are two channels on how to meet the threshold requirement. The first channel is through showing that you have an advanced degree, defined as a master's degree or higher. And or if you have a bachelor's degree in your field and have 5 years of progressive work experience after you earned your bachelor's degree, you can provide a copy of the degree for your bachelor's. And if it's a foreign degree, you will also need to include a U.S. equivalency evaluation report confirming that it is equivalent to a U.S. degree of that level, and also provide letters on letterhead from previous or current employers that can prove that you have indeed 5 full years of progressive work experience with sufficient detail showing how your duties and responsibilities changed in seniority over time and showing that upward trajectory, as I mentioned before. Now, if you're meeting the threshold through showing exceptional ability, you do need to collect at least 3 out of the 7 criteria of evidence that I described earlier. Um, and and really on balance, the government wants to see that the collection of evidence tends to show that you are someone who is operating at a level that is significantly above what is ordinarily encountered in your field, in your profession. And once you provide them the evidence that you meet the EB2 threshold, the other part of the NIW submission is collecting and presenting the evidence that you actually qualify for the national interest waiver under the three-prong matter of the NSR test. So, for national importance and substantial merit, the inquiry is on how can you show the prospective impact of your work. So, things like news articles, academic papers, market research that shows generally the importance of the field to the US government. But importantly, what needs to happen is a detailed description of your particular project, that your specific project, what you're going to do to improve best practices in your field. What is the limitation that the field is currently facing, and what are you doing to, contribute to advancing the envelope of the field, so to speak, or, kind of to, provide the industry with a contribution that is greater than just serving your clients, just providing good services to one employer. So that could be a challenge, but it also could be more approachable and accessible than what people think. There are a variety of evidences that can support that. For example, if you have done, R&D related to your business project, and you have a patent for that technology, and if your plan is to commercialize this technology, publishing a patent is already an evidence of innovation. And so those kinds of, concrete evidence could all, work together to build the argument of what is the prospective impact of your work. Now, with regards to expert letters, it is definitely worth mentioning the important role that expert letters play in preparing a persuasive NIW submission. And expert letters play different roles. Some expert letters can be used to demonstrate substantial merit and national importance of the endeavor if the focus of the expert letter is to describe your business idea or describe your proposed endeavor, your research plans, and that expert can contextualize why it's important for the field to really have this happen now and what is the expected impact of this particular research or this particular business project that you're driving forward. And one thing that's good for the NIW in particular is, especially if your endeavor is located in an economically depressed area, one thing that can very be helpful is if you get letters of support from government entities that's covering that area. So it could be a senator, it could be a congressional representative covering that region. If those government entities, if those representatives of government entities can confirm that your work has this broad influence and national importance, by, significantly advancing policy priorities of that particular region, that can definitely be a very powerful addition to your case in showing national importance. Expert letters also play a good role when, you're trying to bolster your evidence for well position, right? So those types of expert letters can talk about your previous experience of projects that had, broader impact to the field that is related to your proposed endeavor. And those kinds of, mini case studies, by partners that you've worked with, employers that you've worked with in the past, that can really play a big role in contextualizing why your expertise is unique and irreplaceable, and is directly relevant to, making you a good candidate to drive forward that work. Other types of evidences that we typically include are things like the applicant's resumes, professional accomplishments, such as awards in the field, certifications, things like that. Evidence of past projects. So if you have participated in a project that has been publicized widely in media, those things we would, provide a kind of a mini portfolio of those related projects to show that you did have a record of success in the field to support that you're well positioned to advance forward the endeavor. If you are an entrepreneur, one thing that can also be good to show the merits and importance of your work is to include, proofs of industry interest in your business project in the form of contracts, letters of intent with major industry players. That can always be helpful. And as I mentioned before, letters from government entities that can show that government entities are actually invested in your work could also be a powerful, plus factor for your NIW submission. All right, so for the last topic that we'll cover before going to the questions is an example of a case, a successful NIW case, where the case was approved for an entrepreneur. And this can give you kind of a general idea of what the, relevant considerations are and how you can potentially meet those three criteria. So to give a general overview of this particular case, the applicant was an entrepreneur. This person proposed to set up a small consulting firm focused on doing projects with relevant philanthropy and government organizations covering the field of veterans welfare for the purpose of improving the reintegration of wounded warriors to productive society. So if wounded warriors are having a hard time finding, career paths after, being back in civilian society, this consulting business was proposing to help, these government and philanthropy organizations to conceptualize effective programs that met their needs. With regards to substantial merit and national importance, the applicant submitted a variety of evidence that shows why the U.S. needed this intervention. So reports showing the plight, difficulties of returning veterans from Iraq and Afghanistan really showed that the U.S. Suffered from a lack of, such targeted programs to help these wounded warriors. Expert letters from U.S. experts covering the field, including leading U.S. Government senior officials in government organizations, philanthropy organizations, confirmed that really this person's particular business idea could help improve the offerings that are currently available and really contextualized the importance of the particular business project to the USCIS, which was very effective. With regards to well-positioned, how did this person prove that he was well-positioned to advance the proposed endeavor? Really, the question was providing a record of success in similar and related endeavors. In this person who was from the UK, this person was able to provide some very compelling case studies from projects that he had developed in the UK, which had actually seen success. And this was substantiated by things like expert letters, from previous philanthropy leaders in the UK that he had worked in the past. There were some press articles about some of these projects, and the cases, the actual projects that he had conceptualized and ran ended up, connecting hundreds and hundreds of veterans to productive job opportunities, having an actual real world impact. And testimonials about this real world impact was also very effective in proving that this person had the skills and experience, the specific skills to drive forward this business plan. And also, another thing that was really good for this case was that the business plan that this person prepared and submitted was very detailed, and had also included detailed financial plans showing that indeed this was a plausible business plan given the interest of U.S. institutions in the project, and also um, the skills that this person already brought that was unique and not, really replaceable, and very much needed in, the country due to those pressing needs for veterans' welfare. So on balance, the USCIS had no hesitations in, finding that it was beneficial to the United States to waive the requirement of the job offer and labor certification for this particular entrepreneur, based on many different things, including, the broad systemic impact this person's work can have in really improving the program offerings to veterans on a large scale. Also, the benefits, the value of the benefits that this person was able to provide, definitely outweighed the ordinary benefits of a labor certification requirement, which is to save one job spot for one labor, one US person. And also because this person's, record of success was so outstanding and likely irreplaceable with, just another US worker with a similar credential. Definitely the balancing inquiry favored the part of approving the NIW for this applicant. And finally, this person being an entrepreneur, the AAO discussed the fact that it would be impractical for this person to otherwise qualify for a green card under the traditional approach of getting U.S. Company to sponsor this person. This person being an entrepreneur, this was not a practicable approach. So that was another one of the reasons why the balancing inquiry favored the granting of an NIW for this particular applicant.
Wonderful. Well, GA, that was a lot of excellent information. Thank you. I think you answered all of the questions because none came in.
Okay, great.
So
Well,
to our audience, thank you so much for taking the time to join us today. Do keep an eye out for our follow-up email with a link to the PowerPoint and National Interest Waiver Guide, a link where you can sign up for future webinars, and do reach out if you have any questions to schedule a consultation. We offer 30-minute and 1-hour consultations. Of course, we are happy to talk with you about the NIW or really any aspect of U.S. immigration. So thank you again to our audience. GA, thank you again. Everyone stay well and stay healthy, and we look forward to seeing you again soon.